Case 1:24 CV10049 Abel Document 121 filed 030625 page 1 of 55 dated March 6, 2025 Los Angeles, California Liner Friedman Tadelman plus Cooley by S. Brian Friedman Brian J. Friedman Miles M. Cooley Teresa M. Troop Sun Summer Benson Jason Sunshine 1801 Century Park West. 5th floor Los Angeles, California 90067 Telephone 31020100005 Email friedman@lfthup.com Cooley@lfthup.com Troop United States District Court Southern District of New York Blake Lively, Plaintiff v. Wayfarer Studios LC, a Delaware limited liability company Justin Baldoni, an individual, Jamey Heath, an individual, Steve Sarowitz, an individual, IT ends with U.S. Movie LC. A California limited liability company, Melissa Nathan, an individual, the Agency Group PR LLC, a Delaware limited liability company, Jennifer Abel, an individual, defendants. Table of contents removed for your sanity. Page 12 of 55 Consolidated Plaintiffs Wayfarer Studios LLC, Wayfarer, Justin Baldoni, Baldoni, Jamey Heath, Heath. It Ends With Us Movie LLC, IEWU, Melissa Nathan, Nathan, Jennifer Abel, Abel, and Steve Sarowitz, Sarowitz, collectively the Wayfarer Parties. Respectfully submit this memorandum of law in opposition to Consolidated Defendants Leslie Sloane, Sloane, and Vision PR Incorporated. Vision, collectively the Sloane Parties, motion to dismiss the amended complaint for failure to state a claim for attorney's fees and costs, and to strike Exhibit A of the amended complaint, pursuant to Federal Rule of Civil Procedure 12b, 6, and New York's anti-SLAPP law. The motion. Memorandum of Points and Authorities I. Introduction. As alleged in the Wayfarer Parties' first amended complaint, the Sloane Parties played an active and integral role in a conspiracy to inflict harm on the Wayfarer Parties. The conspirators first aimed to win Plaintiff Blake Lively, total control over the film It Ends With Us, the film, by means of extortionate threats to go public with her baseless claims of sexual harassment. That effort wholly succeeded. Having seized complete creative control over the film and its marketing, Lively had only herself and her publicist, Leslie Sloane, and Sloane's company Vision PR Incorporated to blame when her disastrously tone-deaf marketing efforts for the film plowed her public reputation straight into the ground. In a desperate effort to salvage Lively's reputation and to escape her wrath, the Sloane Parties conspired with Lively and Consolidated Defendants Reynolds, and the New York Times Company, New York Times, to make scapegoats of the Wayfarer Parties for Lively's woes. On information and belief, the Sloane Parties worked for months to drop breadcrumbs and hints of sinister allegations to the public while secretly feeding defamatory falsehoods to any reporter who would listen, including Megan Twohey of the New York Times. As a direct result of the actions of the Sloane Parties and one case 1:24 CV10049 Abel Document 121 filed 030625 page 13 of 55 their co-conspirators, the Wayfarer Parties have been damaged beyond measure. Their reputations are destroyed, their businesses lie in tatters, and their own film was taken from them. These are the facts underpinning the Wayfarer Parties' allegations against the Sloane Parties, and this is what the evidence will prove at trial. The motion should be denied in its entirety, or in the alternative, the court should grant the Wayfarer Parties leave to amend their first amended complaint and allow them to move forward with holding the Sloane Parties to account for their part in Lively's malicious and calculated scheme. Lively chose New York as the forum in which to bring her evidence-free claims against the Wayfarer Parties. Although none of them are New Yorkers, the Wayfarer Parties stood ready to defend themselves in any forum and accordingly brought their own claims in this court. But because the Wayfarer Parties suffered their damages in California, where nearly all of them make their personal and professional homes, too, they are entitled to bring their claims under the laws of California, which has a manifest interest in protecting its citizens from defamation and other harms. Yet the Sloane Parties insist that merely because they as defendants have chosen to make their homes in New York, they are entitled to the full weight and protection of New York's laws. regardless of the fact that they reached out across the country to inflict grave and insidious harm on the Wayfarer parties in California. California law should apply to remedy the wrongs suffered in California by California residents and their associates. The Sloane parties complain that they are unable to distinguish the allegations against them from those brought against other parties, arguing that the Wayfarer parties engaged in one because the Wayfarer parties have already once amended their complaint pursuant to Rule 15a(1) of the Federal Rules of Civil Procedure. It is the Wayfarer parties' understanding that they do not have the option to amend as of right pursuant to Rule 15a(1)(b). Out of an abundance of caution, therefore, the Wayfarer parties oppose the motion and the relief sought therein and urge that, if the motion is not denied outright, it be granted only with leave to amend. 2. Steve Sarowitz, the lone exception, is a citizen of Illinois, but he is a party to this action solely by virtue of his ties to the California-based Wayfarer parties. As argued herein, the court can and should apply California law to all the Wayfarer parties' claims. Certainly, the Sloane parties make no argument that Illinois law should apply. 2 Case 1:24 CV10049 OL Document 121 Filed 030625 Page 14 of 55, Impermissible Group Pleading. Of course, it is premature at this stage to require the Wayfarer parties to specify the precise acts taken by the Sloane parties in connection with their conspiratorial scheme. A jury will determine the truth based on the evidence. But until then, the Wayfarer parties have done more than enough to make their allegations against the Sloane parties clear and can easily amend their pleading to add further details based on what they have already learned. Under either California or New York law, the Wayfarer parties have stated a claim for defamation against the Sloane parties. The first amended complaint adequately pleads that the Sloane parties made defamatory statements of and concerning each of the Wayfarer parties, either individually and/or as members of a small and readily identifiable group. Those statements are not inactionable opinion because they are falsifiable. To the extent they contain opinion, that opinion implies the existence of unstated but false and defamatory facts. Nor can the statements be held to be substantially true on the face of the pleadings, because the pleadings set forth a sequence of events entirely inconsistent with the false statements made by the Sloane parties. The Sloane parties' false claims of sexual assault are sufficiently specific to constitute defamation, and the Wayfarer parties need not plead special damages because those statements and others are defamatory per se. Finally, the Wayfarer parties pleaded facts sufficient to allege that the Sloane parties had the requisite state of mind to defame, even under the challenging actual malice standard needed to defame Baldoni, a public figure. The motion falls short with respect to the Wayfarer parties' claim for false light invasion of privacy as well. The Sloane parties' primary argument that New York law, which does not recognize false light claims, must apply, fails for the same reasons that California law must govern the Wayfarer parties' defamation claim. Having made their personal and professional homes in California and having suffered considerable harm there, the Wayfarer parties are entitled to the protection of California's laws. The Wayfarer parties' claim for false light invasion of 3 Case 1:24 CV10049 Eligible Document 121 Filed 030625 Page 15 of 55 Privacy satisfies the Twombly-Iqbal standard for specificity and plausibility of pleading. The Wayfarer parties have done more than enough to give the Sloane parties adequate notice of the allegations against them, and the claims are amply supported by plausible factual allegations sufficient to state a claim for false light. But if the court determines that further factual allegations are necessary to satisfy the pleading requirements, the Wayfarer parties stand ready to supply them by amending their complaint. The motion again misses the mark when it comes to attacking the Wayfarer parties' claim for civil extortion. Again, the Sloane parties insist that New York law, which does not recognize a claim for civil extortion, must apply, an argument that once again fails. The Sloane parties claim that the Wayfarer parties fail to allege that the Sloane parties received anything of value as part of their extortionate conspiracy, but this is not a necessary element of a claim for civil extortion under California law. Furthermore, the Sloane parties err in arguing that they can be held liable for civil extortion only if they themselves directly used force or threats to obtain property from the Wayfarer parties. Like all torts, civil extortion may be pleaded on a theory of liability by conspiracy, as the Wayfarer Parties have done. By pleading that Lively, Reynolds, and the Sloane Parties acted in concert to extort the Wayfarer Parties, the first amended complaint sets forth allegations sufficient to survive a motion to dismiss the claim for civil extortion. Even if the motion is granted, it should be granted only with leave to amend. Federal courts apply an extremely liberal policy in favor of amendment under Rule 15 of the Federal Rules of Civil Procedure. The Wayfarer Parties have already learned substantial additional information since filing the first amended complaint that would enable them to plead further facts in support of their claims. Based on their own investigation and on facts drawn to their attention by concerned citizens from around the country and beyond. Should the court not be inclined to deny the motion in its entirety, the court should grant leave to amend so that this action can be decided on its merits. For Case 1:24 CV10049 Abel Document 121 filed 030625 page 16 of 55 at trial. As part of that amendment, the Wayfarer Parties would endeavor to judiciously incorporate the fulsome chronological account and evidence set forth in Exhibit A to their first amended complaint into the body of the complaint itself, to minimize the burden facing the Sloane Parties as they attempt to counter the admittedly daunting mountain of evidence against the defendants. Finally, even though the motion should be denied, or at most granted only with leave to amend, under no circumstances are attorneys' fees or costs available to the Sloane Parties. Courts of the Second Circuit and of this district are nearly unanimous in holding that the state anti-SLAPP laws of California and New York, which may allow recovery of attorneys' fees, are entirely inapplicable in the federal courts because they conflict with the standards of Rules 11, 12, and 56 of the Federal Rules of Civil Procedure. In short, the motion should be denied. In the alternative, the court should grant the Wayfarer Parties leave to amend their complaint because any defects in the first amended complaint are easily cured based on the facts now available to the Wayfarer Parties. 2. Legal standard to survive a motion to dismiss under Rule 12b. 6 of the Federal Rules of Civil Procedure, a plaintiff must state enough facts to state a claim to relief that is plausible on its face. Bell Atlanta Corp. v. Twombly 550 U.S. 544, 570, 2007. A claim is plausible when the plaintiff pleads factual content that allows the court to draw the reasonable inference that the defendant is liable for the misconduct alleged. Ashcroft v. Iqbal, 556 U.S. 662, 678, 2009. A complaint will be dismissed where the allegations in a complaint, however true, could not raise a claim of entitlement to relief. Twombly 550 U.S. at 558. In ruling on a motion to dismiss, the court must accept the plaintiff's factual allegations as true, drawing all reasonable inferences in favor of the plaintiff. Koch v. Christie's International plc, 699 F.3d 141, 145, 2d Sire 2012. Courts apply an extremely liberal standard for amending pursuant to Federal Rule of Civil Procedure 15a. 2. See Federal R. Civ. P. 5 Case 1:24 CV10049 Oral Document 121 filed 030625 page 17 of 5515. 2. The court should freely give leave to amend a pleading when justice so requires. In Re-Inves. Funding Corp. of New York Secretary Litig. 100 FRD 6465, S.Y. 1983. Describing Rule 15 as embracing an extremely liberal standard with respect to amendment. 3. Factual background: Justin Baldoni is a well-known actor and film director who co-founded Wayfarer in 2019. First amended complaint, v. 20. Wayfarer acquired the film rights to Colleen Hoover's novel, It Ends With Us, in 2019. FAC 22. The book explores themes of domestic violence and generational patterns of abuse. FAC 22. Soon after, Wayfarer partnered with Sony Pictures Entertainment to co-finance and distribute the film. FAC 24. Baldoni took on the role of director as well as male lead character Ryle. FAC 23. On or about December 31, 2022, Blake Lively agreed to take on the lead role of Lily Bloom. FAC 27. She was granted an executive producer credit, but Wayfarer neither requested nor required that Lively contribute to the film in any capacity other than as an actor and executive producer, a vanity credit with no direct responsibility. 23. On or about December 31, 2022, Blake Lively agreed to take on the lead role of Lily Bloom. FAC 27. She was granted an executive producer credit, but Wayfarer neither requested nor required that Lively contribute to the film in any capacity other than as an actor and executive producer, a vanity credit with no direct responsibilities. ID. It initially appeared that Baldoni and Lively would have a productive working relationship, as they collaborated closely in the early days of the production. E.g. FAC 28-30. However, Lively soon began intruding into the production process in ways well beyond the scope of her contractual entitlements. FAC 31. She took over her character's wardrobe and exploded the budget for the role, for example. 32. She also insisted on taking over writing multiple key scenes for the film, resorting to calling in her famous husband and friend as reinforcements when her script rewrites were not received as enthusiastically as she hoped. Edge. Fac 39-42. She began altering the script daily. Edge. Fac 43. Pre-production and the first phase of filming were tenuous, with the Wayfarer Parties tiptoeing around Lively to avoid incurring the wrath of Lively and Reynolds, resulting in delays and significant financial losses in a delicately scheduled production. E.g. FAC 46-50. At one point, Lively issued an ultimatum that if Baldoni could 6 case 1:24 CV10049 Algol document 121 filed 0306 25 page 18 of 55 not get on board with her work methods, he may have to recast her role. FAC 51. Still, Lively reflected a casual, frank manner on the set, for example, inviting Baldoni to join her in her trailer while expressing breast milk and using terms such as sexy, that she later castigated others for using. Edge. Fac 55-62. In May 2023, while filming was underway, the Writers Guild of America, WGA, went on strike, followed shortly thereafter by the SAG-AFTRA strike in July 2023, which caused a hiatus in production pending resolution of the strikes. FAC 63-65. As Baldoni began editing the footage already shot during the strike break, Lively began insisting on access to the dailies. FAC 66-72. The WGA strike ended in September 2023, and the SAG-AFTRA strike ended on November 9, 2023. FAC 73. The same day the SAG-AFTRA strike ended, Lively's lawyer sent an unexpected and confusing 17-point list of non-negotiable demands that must be met before Lively would return to work, apparently drafted for the purpose of falsely insinuating that Baldoni, Wayfarer CEO Jamey Heath, and others had engaged in sexually inappropriate conduct during filming, an entirely false claim. FAC 75. While the Wayfarer Parties disputed and still dispute that Lively's demands had any legitimate predicate, they nevertheless found the requests largely unobjectionable and frequently consistent with existing practices. Edge. Fac 76-112. The discussions over Lively's terms for returning to production culminated in an all-hands meeting on January 4, 2024 at Reynolds and Lively's apartment, where Lively made additional false and unfounded accusations and where Reynolds aggressively berated Baldoni for his purported transgressions. An event that left all the attendees from Wayfarer and Sony shaken and disturbed. FAC 127-131. As Lively admits, however, filming proceeded thereafter uneventfully through the second phase of production, without any further purported incidents of which Lively could complain. FAC 132. However, Lively seized on the opportunity to use her new ammunition, a 7-case 1:24 CV10049 Algol document 121 filed 0306 25 page 19 of 55 carefully constructed paper trail of false insinuations and claims, to complete her forceful takeover of the film from Baldoni, based on the implicit and ever-present threat that she must have her way or she would ruin the Wayfarer Parties. FAC 133. Gradually but in the end completely, Lively took over the editing of the film, ultimately extorting Sony and Wayfarer into releasing her cut despite its poorer performance with audience tests. Fac 134 to 146. She also dictated the film's marketing, erasing Baldoni from promotional material and driving the light-hearted, frothy campaign for the film while peddling her own products, a decision that proved disastrous for her later on. FAC 147 to 149. She continued to insist on greater credit for the film, demanding that Wayfarer support her request for the coveted PJ mark despite not having earned that credit, which denotes a producer who performed the majority of producing work on a motion picture. Fac 152 to 157. As the premiere of the film approached in the summer of 2024, Lively told Sony that she and the rest of the cast would not participate in any marketing or promotion of the film alongside Baldoni, deliberately creating the false impression that Baldoni had committed some serious offense. Fac 158 to 161. On information and belief, Sloane was throughout this time working to spread false and defamatory allegations against the Wayfarer Parties to members of the press, both defaming the Wayfarer Parties and serving as the muscle behind Lively's coercive threats. FAC 187. Upon information and belief, this began well before the backlash against Lively for her wrong-headed marketing efforts for the film, not to mention the self-promotion of her own alcohol and hair care brands. FAC 178 to 187. The FAC details the information known to the Wayfarer Parties at the time of filing about the Sloane Parties' activities to defame and extort them, c.e.g., FAC 188 to 194 to 33. Since filing the first amended complaint, the Wayfarer Parties have obtained additional information about the Sloane Parties' activities during this time and will, if granted leave to amend, add those allegations in their amended pleading. 8 Case 1:24 CV10049 Abel Document 121 Filed 030625 Page 20 of 55. As Wayfarer and Baldoni drifted away from their increasingly erratic publicist, Stephanie Jones, of Jones Works LLC, Jones Works, Jones reacted with vitriol. She seized the phone of departing publicist Jennifer Abel, who was serving as Jones Works' assigned point person for the Wayfarer account, mined it for what she believed to be damning information, and immediately turned over that information to the Sloane Parties. Fac 195, 221, 238. The same day, Sloane called Melissa Nathan and told her that Sloane had seen Nathan's text to Abel and that Nathan should expect to be sued. FAC 238. Now armed with Abel's private text messages and communications, Lively and the Sloane Parties worked hand in glove with the New York Times to concoct a story that would explain Lively's downfall by casting the blame on the Wayfarer Parties. FAC 246. After the Wayfarer Parties finally stood up to Lively and Reynolds and refused to accede to their final demand that the Wayfarer Parties put out a false and humiliating statement admitting blame and wrongdoing, the gloves finally came off. Fact 250 to 256. The Wayfarer Parties allege that the Sloane Parties colluded with Lively, Reynolds, and the New York Times over a period of months to develop a false and defamatory news article and video in conjunction with Lively's unfounded sham complaint filed with the California Civil Rights Department. Fact 256 to 273. As a direct result, the Wayfarer Parties have suffered untold harm. FAC 299. 4. Argument: the motion fails entirely because it cannot show that the Wayfarer Parties failed to meet their pleading burden under Rule 12b-6 and the Twombly-Iqbal standard. California law should apply to each of the Wayfarer Parties' claims, allowing the claims for false light invasion of privacy and civil extortion to proceed, but under the law of either New York or California, the Wayfarer Parties have pleaded a defamation claim against the Sloane Parties sufficient to withstand a motion for dismissal. In the alternative, any defects or inartful pleading in the FAC 9 Case 1:24 CV10049 Algol Document 121 Filed 030625 Page 21 of 55 can easily be remedied by amendment, which is liberally permitted. And the Wayfarer Parties have gathered additional information sufficient to plead further specific facts to support each of their claims against the Sloane Parties, as well as the necessity of applying California law to those claims. Furthermore, the Wayfarer parties can easily amend their complaint to more fully incorporate the allegations of Exhibit A into the body of the complaint, mooting the motion to strike. Finally, even in the extremely unlikely event that the court determines dismissal without leave to amend is appropriate, the Sloane parties are unable to recover their attorneys' fees or costs, as neither California's nor New York's anti-SLAPP laws can apply in the Second Circuit. The FAC gives adequate notice to the Sloane parties under Rule 8. The Sloane parties first argue that the FAC should be dismissed because it does not satisfy the minimum pleading requirements of Federal Rule of Civil Procedure 8 due to impermissible group pleading. See Dis. BR at 5-7. That argument is unavailing. Rule 8 imposes a lenient standard for pleading. Winder v. McMahon 360 F.3 D73, 80, 2 DCIR 2004. Under Rule 8, a pleading need only contain a short and plain statement of the claim showing that the pleader is entitled to relief. Federal R. Civ. P. 8a. 2. Specific facts are not necessary. The pleading need only give the defendant fair notice of what the claim is and the grounds upon which it rests. Erickson v. Partis, 551 U.S. 8993, 2007. Citing Twombly 550 U.S. at 555. Swierkiewicz v. Sorima N.A., 534 U.S. 506, 512, 2002. Solowuden v. Cuomo, 861 F.2 D40 42, 2 DCR 1988. To the extent that minimum requirement is met, the Second Circuit has noted that Rule 8 does not necessarily require that the complaints separate out claims against individual defendants. Winder 360 F.3 D at 80. That is, an authing in Rule 8 prohibits collectively referring to multiple defendants where the complaint alerts defendants that identical claims are asserted against each defendant. Manchanda v. Navient Student Loans, No. 19 CV 5121. 2020 WL 5802238, at 2, SNY September 29, 2020. CVOD Hakashris Crown Heights Inc. vs. Braun, No. 10 Case 1:24 CV 10049. LJL Document 121 Filed 030625 Page 22 of 5515 CV 5857, 2017 WL 101804422. At 5, E-Y January 12, 2017. Same. Vantone Jury. Liab. Co vs. Yangpu NGT Industry Co., No. 13 CV 7639, 2015 WL 4040882, at 3, SNY July 2, 2015. Same. The question is ultimately whether the complaint gives each party notice of the substance of the claims against her. 1 West Bank NAV. Lehman Brothers Holding Inc. No. 14 CV 8916, 2015 WL 1808947, at 3, SNY April 20, 2015. C. Canosa v. SIF, No. 18 CV 4115, 2019 WL 498865, at 10, SNY January 28, 2019. The FAC gives the Sloane parties adequate notice. The FAC alleges the existence of a conspiracy between the Sloane parties, Lively and Reynolds to seed a false and defamatory narrative concerning the Wayfarer parties to various media outlets, including without limitation the Daily Mail and the New York Times. In doing so, the Sloane parties and the Lively parties and the New York Times made a series of defamatory statements. These fall into two principal categories: allegations that certain of the Wayfarer parties, specifically Justin Baldoni and Jamey Heath, engaged in sexual misconduct towards Blake Lively, and allegations that the Wayfarer parties orchestrated a retaliatory smear campaign to damage Lively's image and reputation after she reported their purported misconduct. As alleged in the FAC and discussed herein, those allegations are false, and the Sloane parties knew they were false. To the extent the Sloane parties are grouped throughout the FAC with the Lively parties, that is because they are co-conspirators who engaged in the alleged campaign of defamation collectively. The precise contours of the conspiracy will come into focus through discovery. At this early juncture, and with some notable exceptions, the Wayfarer parties simply have no way of knowing exactly who took what steps as part of the conspiracy. But the Wayfarer parties know and allege that Sloane made statements to reporters referring to Baldoni as a sexual 11 case 1:24 CV10049 Eldrel document 121 filed 030625 page 23 of 55 predator and accusing him of sexual assault. In addition, Sloane ceded false information about Baldoni to the Daily Mail in an effort to divert negative attention from Lively. FAC 190,193. 3. The cases cited by the Sloane parties are either entirely inapplicable or materially distinguishable. In Berdo v. OneCoin Ltd 561 F. Sup. 3D 379, 397, Est and Y 2021. The question before the court was whether the allegations were specific enough to establish personal jurisdiction over each of the defendants, not whether the pleading requirements of Rule 8a were satisfied. The Sloane parties do not contest personal jurisdiction, which is governed by an entirely different and far more fact-intensive legal standard. ID. In Berdo, the lumping together of the defendants prevented an individualized analysis of whether the court could properly assert personal jurisdiction over each of them individually. While the court also dismissed the case on Rule 12b(6) grounds, it was for failure to meet the heightened pleading standard for aiding and abetting and commercial bad faith, not failure to satisfy Rule 8. ID at 412-19 The Check. Com LCV. NEMC FinServes. Very. Inc. No. 16 CV8722 PKC. 2017 WL2627912, at 1, Est and Y June 16, 2017, is an unpublished case that concerns two motions for entry of default judgment. In that case, the plaintiff had completely failed to differentiate between the defendants and did not attribute specific conduct to any of them individually. ID at 3. See also Achuahine v. City of Hartford 10F Apex 33 2021 WL604902 at 34 2D CIR 2021, affirming dismissal of complaint that did not differentiate at all between defendants or identify any factual basis for claims after multiple amendments. To the extent there is a lack of differentiation in the FAC, it does not rise nearly to that extreme. 3. The Wayfarer parties have since obtained additional information specific to the allegations against Sloane that they would add if the motion were to be granted with leave to amend. 12 Case 1:24 CV10049 Abel Document 121 Filed 030625 page 24 of 55. If the court finds merit in the Sloane parties group pleading argument, it should note that the Wayfarer parties intend to move for leave to amend their pleading. The Wayfarer parties' underlying allegations and claims are well grounded in fact and law, and defects of this kind are readily curable to the extent they exist. Under Rule 15 of the Federal Rules of Civil Procedure, the court should freely give leave to amend when justice so requires. Federal Art. Civ. P. 15a. 2. In interpreting Rule 15a, the Second Circuit has explained that district courts should not deny leave unless there is a substantial reason to do so, such as excessive delay, prejudice to the opposing party, or futility. Friedel v. City of New York 210 F.3d 79, 87, 2d CR 2000. See also Block v. First Blood Assox. 988 F.2d 344, 350, 2d CIR. 1993. The rule in this circuit has been to allow a party to amend its pleadings in the absence of a showing by the non-movement of prejudice or bad faith. B. California law, not New York law, applies to the Wayfarer parties' claims against the Sloane parties. The Sloane parties claim that New York law, not California law, should apply to this case. But the weight of authority clearly demonstrates that the appropriate law to apply in this case is the law of California. In diversity cases, federal courts apply the choice of law rules of the forum state. Gilbert v. Seton Hall University. 332 F.3d 105, 109, 2D CIR 2003. See also Claxon Co. vs. Stentor Elect. Manufacturing Co. 313 U.S. 487 496, 1941. Press vs. Primavera 685 F. Sup. 3D 216, 225, SDY 2023. The choice of law rules of New York therefore apply to this case. Press 685 F. Sup. 3D at 225. The first step in that analysis is to determine whether there exists a conflict between the laws of New York and California. Kessner vs. Dow Jones & Co. Inc. 515 F. Sup. 3D 149, 167 S. DNY 2021. See also Condit vs. Dunn 316 F. Sup. 2D 344 352 SDNY 2004. The first inquiry under New York's choice of law analysis is whether there is an actual conflict of laws. Quotation omitted. Matter of Allstate Insurance Company. Stallars. 81N.Y.2D. 219 223 1993. The first step in any 13 case 1:24 CV10049 Eldrel document 121 filed 030625 page 25 of 55 case presenting a potential choice of law issue is to determine whether there is an actual conflict between the laws of the jurisdictions involved. An actual conflict exists where the applicable law from each jurisdiction provides differing rules that have the potential to affect the outcome of the case significantly. Horton vs. Greenwich Hosp. Number 12 CV 4436, 2014 WL 956468, at 2N.1 S. DNY March 10, 2014. Here there exist substantive conflicts between the laws of New York and California as to each of the Wayfarer Parties' claims against the Sloane Parties for defamation, false light invasion of privacy for and civil extortion. As to false light invasion of privacy, the conflict between the two states' laws is total. California recognizes the claim while New York does not. Compare de Havilland v. FX Networks, LLC 21 Calories App. 5th 845, 865, 2018. A false light claim like libel exposes a person to hatred, contempt, ridicule or obloquy and assumes the audience will recognize it as such. With D. Julius v. Engel 2021 WL 4443145, at 9, SDNY September 27, 2021. New York does not recognize the tort of false light invasion of privacy. Quoting Memex Jervy, Inc. vs. Sparrow Fund Management, LP No. 17 Civ. 75688 PGG. 2018 WL 4735717, at 13, SDNY September 29, 2018. The same is true for the civil extortion claim. Again, California recognizes the claim, while New York does not. Compare Minelli vs. Samaya 41A.D.3D. 388, 389, 2007. Extortion and attempted extortion are criminal offenses that do not imply a private right of action. Moreover, although extortionate behavior, coercion and duress may be elements of a cause of action for tortious interference with contract or unjust enrichment, at common law there was never a private cause of action for extortion. Citations omitted, with Furman vs. California Satellite Sys. 179 Calories App. 3D 408 426, 1986. Defendants contend, extortion is only a crime and cannot form the basis for a civil action in tort. We disagree. However denominated e.g. for the claim for false light invasion of privacy is personal to and brought by only Baldoni, Heath, Nathan, Abel and Sarowitz, not by Wayfarer Studios LLC or It Ends With Us Movie LLC. For simplicity's sake, this opposition refers to the claims collectively as being brought by the Wayfarer Parties. 14 Case 1:24 CV10049 Eldrel Document 121 Filed 030625 Page 26 of 55 Extortion, Menace, Duress. Our Supreme Court has recognized a cause of action for the recovery of money obtained by the wrongful threat of criminal or civil prosecution. Citations omitted. Disapproved of on other grounds by Silberg vs. Anderson 50 calories 3D205, 786p.2D 365, 1990. See also Leeper vs. Beltrami 53 calories 2D 195, 202-03, 1959. Woodham vs. Allen 130 calories. 194 198-99 1900. Hisamatsu vs. Nirula 2009 WL4456392, at 5, ND Cal October 22, 2009. California has long recognized a claim of civil extortion. Clearly, there is a total conflict between the laws of California and New York when it comes to these two claims, rendering a choice of law analysis necessary. There are also important differences between the laws of New York and California with respect to the Wayfarer Parties' defamation claim against the Sloane Parties. For example, California extends no greater protection to opinions than does the United States Constitution, while New York law, by contrast, in excess of the United States Constitution, provides for absolute protection of opinions. Condit 317F. Sup. 2D at 352, citing Weller v. Broadcasting Companies, Inc. 232 calories app. 3D 991 1006, 1991, and quoting Cell vs. Filipino reporter enters. 209 F.3D 163, 178, 2D CIR 2000. Because there exists a substantive conflict between the laws of New York and California as to the Wayfarer Parties' claims for defamation, false light, and civil extortion, the court must analyze whether to apply New York or California law to those claims. The choice of law must be analyzed individually as to each claim. De Julius 2021 WL4443145, at 4. New York follows the doctrine of deprecage, under which the choice of law analysis is conducted separately for each individual claim. See also 2002 Lawrence R. Buckelter Alaska v. Philadelphia Finn Life Co. 96F. Sup. 3D 182 200, S. DNY 2015. Under New York law, the choice of law analysis is generally done separately for each claim and defense, under a doctrine called deprecage. Under that doctrine, the rules of one legal system are applied to regulate certain issues arising from 15 Case 1:24, CV10049 Eldrell Document 121 Filed 030625 page 27 of 55 a given transaction or occurrence, while those of another system regulate the other issues. In other words, the deprecage doctrine recognizes that in a single action different states may have different degrees of interests with respect to different operative facts and elements of a claim or defense. Quotations and citations omitted. In defamation cases, New York applies the law of the state with the most significant interest in the litigation. Condit 317F. Sup. 2D at 352, quoting Lee v. Bankers Trust Co. 166 F.3D 540, 545. De Désir. 1999. Under New York choice of law rules in defamation cases, the state of the plaintiff's domicile will usually have the most significant relationship to the case, and its law will therefore govern. Lee 166 F.3D at 545, quoting Reeves v. American Broad. Co. 719 F.2D 602, 605, 2D CR 1983. See also Bricks v. Canadian Broad. Corp. 928 F. Sup. 381, 383, S. DNY 1996, Collecting Cases. Restatement 2nd, of Conflict of Laws 153, 1971. Key state of most significant relationship will usually be the state where the corporation had its principal place of business. Although the preference for the plaintiff's domicile is not conclusive, the significant contacts in a defamation case are almost exclusively the parties' domiciles and the locus of the tort. Lee 166 F.3D at 545, quoting Aerochem International Inc. V. Burkle 968 F.2D 266, 270, 2D Sierra 1992. The interest of a state in a defamation action is significant and incontrovertible, where the plaintiffs are citizens of that state and live and conduct their business there. Adelson v. Harris, 973 F. Sup. 2D 467, 477-78, Eston Y. 2013. Though New York may have some interest in the Wayfarer Parties' defamation claim against the Sloane Parties because the Sloane Parties are residents of New York, California has a much more significant interest because nearly all of the plaintiffs' 5 are residents of California or have their principal place of business there. The 2 corporate plaintiffs, Wayfarer Studios LLC and It Ends With Us Movie 5. The only plaintiff who is not a resident of California is Steve Sarowitz, who resides in Illinois. No party has to date advanced an argument that the law of Illinois should apply to any claim in this action. Moreover, Sarowitz's connection to this action is through his ties to Wayfarer, which is located in California. 16 Case 1:24 CV10049 Algel Document 121 Filed 030625 Page 28 of 55 LLC, are both incorporated and or have their principal place of business in California. The plaintiffs suffered injury to their reputations in California 6. And the economic losses to the plaintiffs were all felt in California. La Luna Enters, Inc. v. CBS Corp. 74 F. Sup. 2D 384-389, Esty 1999. Moreover, it was entirely foreseeable to the Sloane Parties that the harm of their wrongful and defamatory actions would be felt primarily in California, therefore rendering it inherently just that the Sloane Parties' conduct should be regulated pursuant to the laws of California. Particularly given that the bulk of the defamatory acts were conducted, and the defamatory statements were published primarily via the Internet. Adelson, 973 F. Sup. 2D at 480-81. Although communities in the United States with little or no Internet usage still exist in general, it is quite foreseeable that the brunt of the reputational harm that results from Internet-based defamation is most likely to be felt in the forum where the defamed individual lives, works, and maintains social relationships. Quoting Centric Ventures, LCV, Bird 683 F. Sup. 2D 1068-1073, Arizona 2010. Here each of the Wayfarer Parties lives, works, and/or maintains social relationships in California, and the law of California should therefore apply. In addition, the underlying New York Times article, which is in many respects the genesis of this entire action, is purportedly based on reporting relating to Lively's complaint filed with California's Civil Rights Department, which purported to assert claims for violation of California's Fair Employment and Housing Act and Labor Code. FAC 4. 262. Sloane. Parties also gloss over the undeniable fact that the film's production, the purported site of the majority of Lively's unfounded allegations, took place not in New York but in New Jersey. FAC 6. The first amended complaint alleges that the Wayfarer Parties also suffered injury in New York as well as in their home state of California, which is a true statement notwithstanding the fact that the bulk of the harms were felt in California. To the extent that additional allegations are necessary to cure any inartful pleading as to the primary location of the harms, the court should grant leave to amend pursuant to the extremely liberal standard of Federal Rule of Civil Procedure 15. 2. Federal R. Civ. 15a. 2. The court should freely give leave to amend a pleading when justice so requires. In Re-Inves. Funding Corp. of New York Secretary Litig. 100 FRD at 65, describing Rule 15 as embracing an extremely liberal standard with respect to amendment. 17 Case 1:24 CV10049 Algel Document 121 Filed 030625 Page 29 of 55 XA, at 51. Yet the Sloane Parties have not proposed that New Jersey law should apply to this action. In short, the laws of California can and should supply a remedy for the harms felt primarily in California by plaintiffs, who all live, work, and/or do business in California, as the result of conduct aimed at California. C. The FAC states a claim for defamation against the Sloane Parties regardless of which state's law applies, the Wayfarer Parties have pled a legally sufficient defamation claim against the Sloane Parties. Under California law, defamation is an invasion of the interest in reputation. The tort involves the intentional publication of a statement of fact that is false, unprivileged, and has a natural tendency to injure or which causes special damage. Smith v. Maldonado, 72 calories App. 4th 637, 645, 1999. Defamation may consist of either libel or slander. Calciv. Code 44. Libel, which is at issue here, is defined as a false and unprivileged publication by writing, printing, picture, effigy, or other fixed representation to the eye, which exposes any person to hatred, contempt, ridicule, or obloquy, or which causes him to be shunned or avoided, or which has a tendency to injure him in his occupation. Calciv. Code 45. Where the defamation is clear without the need for any explanation, it is considered defamation per se and damages are presumed. Contento v. Mitchell, 28 calories App. 3D 356, 358, 1972. An action for damages based on language defamatory per se, damage to the plaintiff's reputation is conclusively presumed and he need not introduce any evidence of actual damages in order to obtain or sustain an award of damages. Where the defamation is not per se and some explanation is needed to show why the statement was defamatory, the plaintiff is required to allege and prove that he or she suffered special damages, such as harm to reputation, shame, or economic damages. Calciv. Code 4548A. 18 Case 1:24 CV10049 OL Document 121 Filed 030625 Page 30 of 55 To state a claim for libel per se under New York law, a plaintiff must allege 1. A written defamatory statement of fact concerning the plaintiff. 2. Publication to a third party. 3. Fault, either negligence or actual malice, depending on the status of the libeled party. 4. Falsity of the defamatory statement. And 5. Special damages or per se actionability. Palin v. New York Times Co., 940 F.3d 804, 809, 2 DCIR 2019. At the pleading stage, the falsity of the alleged defamatory statements is presumed. Treple v. BioVale Corp., 2005 WL 2086339, at 8, Eston August 30, 2005. The court must decide only whether the statement alleged to have caused plaintiff injury are reasonably susceptible to the defamatory meaning imputed to them. Restis v. Against Nuclear Iran Inc. 53 F. Sup. 3D 705, 718, Eston 2014. Quotations omitted. There is no question that, under the laws of both California and New York, the Wayfarer Parties state a plausible claim for defamation per se. 7.1. The Sloane Parties made defamatory statements of and concerning the Wayfarer Parties as to Baldoni. The FAC alleges that the Sloane Parties made one or more statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that Baldoni is a sexual predator who sexually assaulted Lively FAC 8, 193-82, and that Baldoni retaliated against Lively and others for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. 325. The FAC alleges that the Sloane Parties made further false statements in response to media inquiries concerning Lively's wrongful accumulation of power. 7. The Sloane Parties' attempt to invoke the fair report privilege under New York Civil Rights Law 74 is unavailing. The purpose of Section 74 is to avoid stifling an active, thriving, and untrammeled press and to ensure that the press receive broad protection. Sender. 4. Med. Progress v. Planned Parenthood Fed N of AM. 551 F. Sup. 3D 320-331, Eston 2021. Quoting IDEMA v. Wagner 120 F. Sup. 3D 361-365, Eston 2000. Citation omitted. Aft 29 F. Apex 676, 2D CIR 2002. Not only are the Sloane Parties not members of the press, the FAC alleges that they were responsible for feeding the defamatory information at issue to the press. Furthermore, the statute may not be invoked where a party maliciously institutes a judicial proceeding alleging false and defamatory charges as a vehicle to publish and disseminate those charges. RCI Hosp. Holdings Incorporated. v. White 220A.D.3d. 430-430, 2023. Citing Williams v. Williams, 23N.Y.2d. 592, 599, 1969. 19 Case 1:24 CV10049 Obel Document 121 Filed 030625 Page 31 of 55 Over the production, the means by which she did so, i.e. false accusations of sexual misconduct, and the resulting turmoil. Specifically, the Sloane Parties stated to the Daily Mail among others that reports of a power struggle on set were 1000% untrue. Your info is totally off. You have it all wrong. Your reporters are so wrong. FAC 189 to 190. Instead, the Sloane Parties ceded false information to cast Baldoni, rather than Lively, in a false light. The whole cast doesn't like Justin, nothing do with Blake. They, the Wayfarer Parties, are panicking as the whole cast hates him, Baldoni. FAC 190. As to the other Wayfarer Parties, the FAC alleges that the Sloane Parties made one or more statements to third parties, including without limitation to the New York Times and other news outlets, to the effect that the Wayfarer Parties engaged in permitted and or failed to prevent sexually inappropriate conduct toward Lively and others and retaliated against Lively for reporting the alleged sexual misconduct, including by propagating false and misleading narratives about Lively for the purpose of damaging her image and reputation. FAC 273, 274, 276, 325. As alleged in the the Sloane Parties told the New York Times a false and damning story about an insidious PR sabotage operation deployed as revenge for sexual harassment complaints, with the knowledge and intent that the newspaper would publish the false story. FAC 273, ID. 276. The Sloane Parties propounded a false, smear campaign narrative designed to destroy the Wayfarer Parties. The Sloane Parties contend that the FAC fails to allege that the Sloane Parties made defamatory statements of and concerning the Wayfarer Parties other than Baldoni. A statement upon which a defamation claim is based must specifically refer to or be of and concerning the plaintiff in some way. Blatty v. New York Times Co. 42 calories. 3D 1033, 1043, 1986. Contested statements must be of and concerning the individual either by name, i.e. referring personally to the individual, or by clear implication. See also Jackson v. Mayweather 10 calories app. 5th 20 Case 1:24 CV10049 Olgol Document 121 Filed 030625 Page 32 of 55 1240, 1259, 2017. The defamatory statement must specifically refer to or be of or concerning the plaintiff. Internal citations omitted. The same is true under New York law. See Kirch v. Liberty Media Corp. 449 F.3d 388, 398-99, 2D Sear 2006. Allegedly defamatory statements must be of and concerning the plaintiff. Elias v. Rolling Stone LC, 872 F.3d 97, 104-05, 2D Sear 2017. It is not necessary that the world should understand the libel. It is sufficient if those who know the plaintiff can make out that she is the person meant. Quoting Geisler v. Petrocelli, 616 F.2d 636, 639, 2D Sear. 1980. See also Daytree at Cortlandt Square Inc. v. Walsh 332 F. Sup. 3D 610 629 Y 2018. Noting that courts in the Second Circuit require a reasonable connection between the plaintiff and the libel. Internal quotation marks and citation omitted. There is no question that requirement is satisfied here. As alleged in the FAC, all of the Wayfarer parties, including those without a public profile, have become figures of infamy and derision as a result of the Sloane Parties' defamatory statements, which were widely disseminated and universally understood to refer to them. Fac 1-5. Furthermore, the of and concerning requirement is generally an issue of fact for the jury to decide, and the court may properly dismiss an action only where the libelous statement is incapable of supporting a jury's finding that it refers to the plaintiff. Green v. Paramount Pictures Corp. 138 F. Sup. 3D 226, 234 Y 2015. Quoting Church of Scientology International v. Time Warner, Inc., 806 F. Sup. 1157 1160, Hys Y 1992. Aft sub nom. Church of Scientology International v. Behar, 238 F.3D 168, 2D Sierra 2001. This is not a situation in which a jury would be incapable of finding that the statements at issue refer to each of the Wayfarer parties. Any doubts raise a question of fact for the jury and not a question of law for the court. C. Diaz v. NBC Universal Inc. 536 F. Sup. 2D 337 343 Aft 337 Federal Acts. 94, 2D CIR 2009. Jury generally decides whether defamatory statement is of and concerning plaintiff. 21 Case 1:24 CV10049 Oval Document 121 Filed 030625 Page 33 of 55 and the Wayfarer Parties' allegations implicate the small group exception of the group libel doctrine. Under the group libel doctrine, typically, a statement made about an organization is not understood to refer to any of its individual members unless that person is distinguished from other members of the group. 3 Amigos Estelle Rest, Inc. v. CBS News Incorporated. 15N.Y.S.3d. 3641 First Step 2015. Aft 28N.Y.3d. 82, 2016. But where a statement defames all members of a small group, the reference to the individual plaintiff reasonably follows from the statement. Brady v. Ottaway Newspapers Incorporated. 445 N.Y.S.2d. 786, 790, 2d Dept 1981. Accordingly, an individual belonging to a small group may maintain an action for individual injury resulting from a defamatory comment about the group, by showing that he is a member of the group. ID. See also Algarin v. Town of Wallkill 421 F.3d 137, 139, 2D Sierra 2005. Church of Scientology of California v. Flynn, 744 F.2d 694, 697 N.5, 9th Circle 1984. Ball v. Taylor. 416 F.3d 915, 8th Circle 2005. Per curiam. Finding small group exception applied where statement defamed approximately 100 individuals. Here there are 7 members of the Wayfarer parties, well below the ceiling of the group libel doctrine, and the Sloane Parties statements defamed all of them. 2. The Sloane Parties statements are not inactionable opinion. The Sloane Parties further contend that the defamatory statements attributed to them constitute inactionable opinion. Dis. Br at 7-14 They are wrong. Under California law, in order to constitute actionable defamation, the offensive publication must consist of statements of fact, rather than opinion. Summit Bank v. Rogers, 206 Calories App. 4th 669, 695-96, 2012. A statement can be defamatory only if it is capable of being proved as true or false. See Savage v. Pacific Gas and Electric Co., 21 Calories App. 4th 434-445, 1993. Jensen v. Hewlett-Packard Co. 14 Calories App. 4th 958, 970-71, 1993. Statements do not imply a provably false factual assertion and thus cannot form the basis of a defamation action if they cannot 22 Case 1:24 CV10049 Eldrell Document 121 Filed 030625 page 34 of 55 reasonably be interpreted as stating actual facts about an individual. Thus, rhetorical hyperbole, vigorous epithets, lusty and imaginative expressions of contempt, and language used in a loose, figurative sense have all been accorded constitutional protection. Selig vs. Infinity Broad. Corp. 97 Calories App. 4th 798, 809, 10, 2002. But apparent expressions of opinion often imply an assertion of fact and are therefore actionable. Weller vs. American Broadcasting Companies, Inc. 232 Calories App. 3D 991, 999, 1991. Thus, a statement in the form of an opinion may be actionable if it is implied that it is based on some undisclosed defamatory facts. Baker v. L.A. Herald Examiner, 42 Calories 3D 254, 266, 1986. Oken v. Superior Court, 29 Calories 3D 442, 451-52, 1981. The issue of whether the statement is fact or opinion is one for the jury. Slaughter vs. Friedman, 32 Calories 3D 149, 154, 1982. As for the court, the dispositive question is whether a reasonable fact finder could conclude that the published statements imply a provably false assertion of fact. Moyer vs. Amador Valley Joint Union High School District, 225 Calories App. 3 des 720, 724, 1990. To answer that question, the court applies a totality of the circumstances test pursuant to which the court reviews the language of the statement and the context in which the statement was made. Baker 42 Calories. 3D at 260-61. A statement is factually specific, earnest, or serious in tone, or the speaker represents himself as unbiased, having specialized or first-hand experience, or having personally witnessed abhorrent behavior. This may signal that there is a factual basis for the accusations and render the statement actionable. ZL Technologies Inc. v. Does 1-7 Calories. App. 5th 603, 624, 2017. Internal citations omitted. Whether a challenged statement declares or implies a provable false assertion of fact is a question of law for the court to decide. Unless the statement is susceptible of both an innocent and a libelous meaning, in which case the jury must decide how the statement was understood. Overhill Farms Inc. vs. Lopez 190 Calories App. 4th 1248-1261, 2010. Internal citations omitted. 23 Case 1:24 CV10049 Algol Document 121 Filed 030625 page 35 of 55 Courts applying New York law generally consider 1. Whether the specific language and issue has a precise meaning which is readily understood. 2. Whether the statements are capable of being proven true or false. And 3. Whether either the full context of the communication in which the statement appears or the broader social context and surrounding circumstances are such as to signal readers or listeners that what is being read or heard is likely to be opinion, not fact. Bryan vs. Richardson, 87N.Y.2d. 46-51 1995. Internal quotation marks and citations omitted. Accord Cell 209 F.3d at 178-79. The analysis is not rigid. Court must have the flexibility to consider the relevant factors and to accord each the degree of importance which the specific circumstances warrant. Steenhilber vs. Alphone, 68N.Y.2d. 283, 291-92, 1986. The Court of Appeals in New York has consistently focused its analysis on the overall context in which the complaint of assertions were made. Flam v. Association of University Women, 201 F.3d 144, 153, 2d CIR 2000. Context includes not only the immediate context in which the disputed words appear, but also the larger context in which the statements were published, including the nature of the particular forum. Bryan 87N.Y.2d. At 51. If a statement is found to contain opinion, that is not the end of the inquiry. The court must then examine whether the statement is pure opinion, and thus non-actionable, or mixed opinion, and therefore actionable. Chow v. Lewis, 771 F.3d 118, 129, 2d CIR 2014. The actionable element of a mixed opinion is not the false opinion itself. It is the implication that the speaker knows certain facts, unknown to his audience, which support his opinion and are detrimental to the person about whom he is speaking. Steenhilber 68 N.Y.2d. At 290. Ultimately, the dispositive inquiry is whether a reasonable reader could have concluded that the statements were conveying facts about the plaintiff. Gross v. New York Times, 82 N.Y.2d. 146 152 1993. Alteration adopted. Internal quotation marks and citation omitted. Restus F. Sup. 3D at 24 Case 1:24 CV10049 Uljol Document 121 Filed 030625 Page 36 of 55 719. At bottom, the inquiry is whether a reasonable listener is likely to have understood the statements as conveying provable facts about the plaintiff. Here the alleged statements are either direct statements of fact or statements that imply the existence of undisclosed facts. All are susceptible to a defamatory meaning. Notwithstanding the Sloane Parties' bizarre argument to the contrary, it is clearly a statement of fact to accuse someone of having committed sexual assault. Buckley v. Little 539 F.2d 882, 894, 2d Cr 1976. Sexual assault accusation, readily perceivable as allegations of fact susceptible to proof or disproof of falsity. The statement referring to Baldoni as a sexual predator also cannot reasonably be construed as an expression of pure opinion. At a minimum, it implies a provably false assertion of fact and lends itself to a defamatory meaning. As alleged in the FAC, it was intended to convey that Baldoni had committed sexual assault. The Sloane Parties' other statements about Baldoni are similarly libelous. See FAC 189190. Publishing the statements to a reporter that he whole cast doesn't like Justin nothing do with Blake, and the Wayfarer Parties are panicking as the whole cast hates him, were clearly and inarguably intended to convey undisclosed facts of a defamatory nature. FAC 190. As alleged in the FAC, it is false that any issues between Baldoni and the cast, especially in relation to the promotion of the film, had nothing to do with Lively. Fac 146, 159. A reasonable reader would, and the Daily Mail reporter did, interpret Sloane's statements to mean that Baldoni had engaged in misconduct or had otherwise, through his own actions, caused them to turn against him. But that is neither what happened nor what is alleged in the FAC. Indeed, the Wayfarer Parties allege that Lively induced the other cast members to shun Baldoni, in an early attempt to give fans the impression that Baldoni had committed an egregious sin, something so egregious that no one wanted to even take photos with him or have him around. FAC 159. Prior to Lively's inducements, these same cast members showered warm praise 25 Case 1:24 CV10049 OL Document 121 Filed 030625 Page 37 of 55 and appreciation, on Baldoni. ID. One female cast member prior to Lively's inducements exchanged grateful texts with Baldoni during and after her filming stint, which included a number of scenes involving intimacy. ID. That actress worked with Baldoni when Lively was not on the set. It was not until she spent substantial time with Lively during film promotions that she felt compelled to shun Baldoni in repudiation of her warm words. ID 160. The Sloane Parties' statements about the rest of the Wayfarer Parties are likewise false statements of fact. Specifically, the Sloane Parties made statements that the Wayfarer Parties engaged in, permitted and or failed to prevent sexually inappropriate conduct toward Lively and others and orchestrated a smear campaign in retaliation for Lively's purportedly protected disclosure of such conduct. Fac 14-15, 17, 272. The allegations in the FAC are unequivocal. None of the Wayfarer parties engaged in any kind of misconduct towards Lively. The Wayfarer parties did not permit or fail to prevent such misconduct, and the Wayfarer parties did not orchestrate a smear campaign in retaliation for Lively's purported disclosures. As alleged in the FC, the tidal wave of negative publicity that Lively confronted in August 2024 was the unsurprising result of tone-deaf marketing, off-putting public appearances, and the excavation by internet sleuths of unflattering prior interviews. Fac 10, 178-185, 279, 282-281. The Sloane Parties statements imply that the Wayfarer parties engaged in grossly immoral conduct to cover up even more grossly immoral conduct, and such statements resulted in the destruction of their reputations and careers, among other cataclysmic consequences. The statements cannot be and were not construed as mere statements of opinion or of hyperbole. They were statements of fact and they were false. And if a court concludes that the statement could be reasonably construed as either fact or opinion, the issue should be resolved by a jury. Good Government Group of Seal Beach Inc. vs. Superior Court, 22 calories 3D 672, 680. 1978. In either event, the motion should be denied in this respect. 26 Case 1:24 CV10049 Aldril Document 121 Filed 030625 page 38 of 55-3. The Sloane Parties statements are not substantially true. The Sloane Parties also urge the court to dismiss the Wayfarer Parties defamation claim on the grounds that the alleged statements are substantially true. Dis. BR at 14. It is of course axiomatic that truth is an absolute defense to any libel action. Campanelli vs. Regents of University of Cal 44 calories App. 4th 572, 581 to 582, 1996. California law permits the defense of substantial truth and would absolve a defendant even if she cannot justify every word of the alleged defamatory matter. It is sufficient if the substance of the charge be proved true, irrespective of slight inaccuracy in the details. Minor inaccuracies do not amount to falsity so long as the substance, the gist, the sting of the libelous charge be justified. Get Fugu Inc. vs. Patton Boggs LLP, 220 calories App. 4th 141, 154, 2013. Quoting Masson v. New Yorker Magazine Incorporated. 501 U.S. 496, 516 to 517, 1991. The same is true under New York law. C.e.g. Tannerite Sports, LCV. NBC Universal News GRP. 864 F.3D 236, 245-50, 2 DCIR 2017. However, truth is a question of fact for the jury. Maheu vs. Hughes Tool Company. 569 F.2D 459, 465-66, 9th Circle 1977. Concluding in a defamation action that there was a jury question as to whether allegedly defamatory utterances were substantially true. DRE America vs. Rolling Stone Magazine, 101 F. Sup. 2D 1270-1288 CD Cal 2000. Holding that substantial truth is a jury question, so long as substantial truth is not evident to the court. The only exception when substantial truth is evident to the court is not remotely the case here. DRE America 101 F. Sup. 2D at 1288. Taking the allegations in the FAC as true as the court must on a Rule 12b, 6, motion, the court simply cannot conclude as a matter of law that a. Baldoni sexually assaulted Lively. 2. Baldoni is a sexual predator. 3. Lively had nothing to do with the cast's alienation from Baldoni during the promotion of the film. 4. The Wayfarer Parties orchestrated a smear campaign in retaliation for Lively's purported disclosure that she had been sexually harassed. 27 Case 1-24 CV10049 Uldrel Document 121 Filed 030625 Page 39 of 55. All of these propositions are expressly denied by the Wayfarer Parties in the FAC, and there is extensive elaboration on the basis for their denials. The Sloane Parties' statements clearly have a different effect on the mind of the reader from that which the pleaded truth would have produced. Jackson 10 Calories App. Fifth at 1262-1263. Fleckenstein v. Friedman 266 New York 1923-1934. A statement is only substantially true if the statement would not have a different effect on the mind of the reader from that which the pleaded truth would have produced. Cf. Caro Capadal, LCV. Koch 2021 WL 1595843, at 11, Eston Y. April 23, 2021. Substantial truth in reference to felon's prison sentence when 78-month sentence ultimately reduced to time served. However, this case does not present a question of slight inaccuracies of expression, but rather of fundamentally different realities. Corcola v. W. W. Norton and Company. 618 F. Sup. 152, 155, Eston Y. 1985. While the Sloane Parties appeal to Lively's allegations in her pleading, those allegations are not properly before the court on this motion. The Wayfarer Parties adamantly deny the veracity of the Sloane Parties' accusations in their FAC not on technical or marginal grounds but rather as flatly false. The court is in no position to rule that the statements are substantially true based on the Wayfarer Parties' pleadings. A jury must ultimately decide truth or falsity. 4. The alleged statements concerning sexual assault are sufficiently specific. The Sloane Parties also contend that the statements concerning sexual assault are insufficiently specific to defend against. Dis. BR at 16-17. That is in spite of the fact that, in the same motion, they also contend that the statements are inactionable opinion and or substantially true. Dis. BR at 11-16. The federal rules require that each pleading be specific enough to afford the defendant sufficient notice of the communications complained of to enable him to defend himself. Burton v. Label LC, 344 F. Sup. 3D 680, 699, S. DNY 2018. Quoting Biro v. Condé Nast, 883 F. Sup. 2D 441 445, SDY 2012. The defamation case cited by the Sloane Parties and dismissed by this honorable court involved allegations so threadbare as to be irrelevant here. 28 Case 1:24 CV10049 Obel Document 121 Filed 030625 Page 40 of 55 C. Evlioglu Textile ASV. Turco Textile LC. 2020 WL 77743777, at 1, Eston Y. December 30, 2020. Defamation counterclaim dismissed where pleadings consisted of general allegation that counterclaim defendant threatened to make false statements about counterclaimant and allegation on information and belief that he did so. The Sloane Parties appear to have confused the rules of pleading with the rules of evidence. Semple v. Andrews 27 Calories App. 2D 228 233 1938. Distinguishing what a plaintiff must assert to plead a cause of action for defamation from what a plaintiff must prove at trial. Schessler v. Keck 125 Calories App. 2D 827 835-36, 1959. Statements allegedly made, at various times and places and to various persons, sufficient to state a claim for defamation. As the court explained, less particularity is required in the allegations of the complaint where, from the nature of the matters alleged, the adverse party has a knowledge of the facts superior to the party pleading them. ID, Oken 29 Calories. 3D at 458. That is clearly the case here. The Sloane Parties also appear to confuse the applicable pleading standard. A plaintiff asserting a state law defamation claim in federal court need only satisfy Rule 8. A state's heightened pleading requirement such New York's does not apply. See Church of Scientology, 744 F.2d at 696 N.2, See also Anderson v. Diorio, 349 F.3d8, 17, First Circle 2003. Musikowski v. Paramount Pictures Corp., 322 F.3d 918, 925-26. Seventh Circle 2003. Thus, the Sloane Parties citation to BCRE 230 Riverside LLC v. Fuchs, 59A.D.3d. 282-283 First Dep 2009, is entirely inapposite because it pertains to CPLR 3016, which imposes a heightened pleading requirement that does not exist for defamation claims under the federal rules. See Biro 883F. Sup. 2D at 456, defamation claims in federal court are subject to the liberal pleading standards of federal R. Civ. P. 8-inch rather than the particularized pleading requirements set forth in CPLR 3016. See also Neal v. Asta Funding Inc. No. 13 CV 2176 VB, 2014 WL 3887760 at 3. Estin Y. June 17, 2014. Mobile Data Shred Incorporated. V. United Bank of Switzerland, No. 99 CIV. 10315 SS, 2000 WL 351516, at 629 Case 1:24, CV10049 Elwell Document 121 Filed 030625 Page 41 of 55, Estin Y. April 5, 2000. The Wayfarer parties have met their pleading burden under Rule 8 even as the contours of the conspiracy will further come into focus. Through discovery. 5. The Wayfarer parties need not plead special damages because the Sloane party statements are defamatory per se. The Sloane parties' argument that the Wayfarer parties' defamation claim fails for failure to plead special damages is unavailing because plaintiffs need not plead such damages where, as here, the alleged statements are libelous per se. California law recognized two types of libel: libel per se and libel per quot. See Bartholomew v. YouTube, LC, 17 Calories App. 5th 121, 1226, 2017. A statement constitutes libel per se when it is defamatory of the plaintiff without the necessity of explanatory matter, such as an inducement, innuendo or other extrinsic fact. Calciv. Code 45A. Accord Overstock.com Inc. V. Gradient Analytics, Inc. 151 Calories App. 4th 688, 700, 2007. The distinction has been described as follows. If no reasonable reader would perceive in a false and unprivileged publication a meaning which tended to injure the subject's reputation in any of the enumerated respects, then there is no libel at all. If such a reader would perceive a defamatory meaning without extrinsic aid beyond his or her own intelligence and common sense, then, under Section 45A and the cases which have construed it, there is a libel per se. But if the reader would be able to recognize a defamatory meaning only by virtue of his or her knowledge of specific facts and circumstances, extrinsic to the publication, which are not matters of common knowledge rationally attributable to all reasonable persons, then, under the same authorities, the libel cannot be libel per se but will be libel per quot. Bartholomew 17 Calories App. 5th at 1226-27 quoting Barnes-Hind, Inc. vs. Superior Court, 181 Calories App. 3D 377, 386-87, 1986. Whether a publication is libelous on its face is a question of law. Freeman vs. Mills, 97 Calories App. 2D 161, 16566, 1950. He publication is to be measured not so much by its effect when subjected to the critical analysis of a mind trained in the law, but by the natural and probable effect upon the mind of the average reader. A defendant is liable for what is insinuated as well as for what is stated explicitly. Bartholomew 17 Calories App. 5th at 1227, citing McLeod v. Tribune Publishing Co. 52 Calories 2D 536, 547-48, 1959. 30 Case 1:24 CV10049 Obel Document 121 Filed 030625 Page 42 of 55 The same is true under New York law. A statement is actionable without alleging special damages if it tends to expose the plaintiff to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of him in the minds of right-thinking persons, and to deprive him of their friendly intercourse in society. Sidney v. McFadden Newspaper Pub Corp., 242 New York 208, 21112 1926. Accord Rinaldi v. Holt, Reinhardt and Winston, Inc. 42N.Y.2d. 369 379, 1977. No need for plaintiff to allege special damages when statement is defamatory per se. All of the Sloane Parties' alleged statements are defamatory per se. As to the statements concerning Baldoni being a sexual predator who committed sexual assault, there is no question these are defamatory per se. Perhaps the clearest example of libel per se is an accusation of crime. Barnes-Hind 181 Calories App. 3D at 385. Sexual assault is obviously a crime, and referring to someone as a sexual predator is intended to and does convey an impression of criminality and malice. CFE 8. Modern society justly reviles sexual harassers and abusers, and Lively and her co-conspirators knew full well that making those allegations would be a career death sentence for the Wayfarer Parties. The statements concerning the rest of the cast hating Baldoni conveys an impression of some undisclosed, egregious sin, something so egregious that no one wanted to even take photos with him or have him around. FAC 159. With respect to the other Wayfarer Parties, there is similarly no question that the statements at issue are defamatory per se. The crux of the accusations is that the Wayfarer Parties engaged in and/or condoned sexual misconduct and took revenge on the victim of such misconduct through a scorched earth public relations vendetta. These allegations tend to expose the Wayfarer Parties to public contempt, ridicule, aversion, or disgrace, or induce an evil opinion of them in the minds of right-thinking persons, and to deprive them of friendly intercourse in society. Sidney 242 at 211-12 As to IEWU and Wayfarer, it is well settled that a statement that impugns the basic integrity of a business is per se defamatory. Boole v. Hutton, 328 F.3d 84-94, 2d Cir 2003. C31 Case 1:24 CV10049 Obel Document 121 Filed 030625 Page 43 of 55 Also Rinaldi, 42N.Y.2d. At 379, falsely referring to a judge as incompetent and corrupt where there are strong undertones of illegality, subjects him to disgrace and contempt and is therefore defamatory per se. Those are exceedingly serious accusations that tend to subject and already have subjected the Wayfarer Parties to reputational collapse and public derision. On the face of these allegations, the pleading of special damages is unnecessary. 8.6. The Wayfarer Parties have pleaded actual malice. The Sloane Parties further contend that the Wayfarer Parties' defamation claim fails for failure to plead the requisite state of mind. Dis. BR at 17-18. Specifically, they argue that Baldoni is a public figure and thus cannot state a claim for defamation without plausibly alleging that the Sloane Parties made the alleged statements with actual malice. This argument fails for two reasons. First, as to Baldoni, the Wayfarer Parties have unequivocally pled facts sufficient to infer actual malice. Second, the other Wayfarer Parties are not public figures, and therefore pleading actual malice is not required to state a claim for defamation. For the purposes of this motion alone, the Wayfarer Parties presume the application of the actual malice standard and submit its pleading burden has been satisfied. As a matter of constitutional law, if the person defamed is a public figure, he must prove by clear and convincing evidence that the statement at issue was made with actual malice, i.e., with knowledge that it was false or with reckless disregard of whether it was false or not. Reader's Digest Association v. Superior Court, 37 Calories 3D 244, 256, 1984. Citing New York Times Co. v. Sullivan, 376 U.S. 254, 285-86, 1964. See also Biro v. Condé Nast, 807 F.3d 541. 544, 2d CIR 2015. The Supreme Court has explained that while the concept of reckless disregard cannot be fully encompassed in one infallible definition, the defendant must have made the false publication with a high degree of awareness of probable falsity, or must have entertained serious aid in the event the court determines that any of the foregoing are not, in fact, defamatory per se. The Wayfarer Parties respectfully request the opportunity to amend their pleading so as to allege special damages. 32 Case 1:24 CV10049 OL Document 121 Filed 030625 Page 44 of 55 Doubts as to the truth of his publication. Hart-Hanks Communications, Inc. v. Connaughton 491 U.S. 657, 667, 1989. The FAC is replete with allegations that the Sloane Parties made the alleged defamatory statements with knowledge of their falsity or reckless disregard for their truth or falsity. See, e.g., FAC 3-4, 68, 14-15, 17, 162, 187-194, 244, 246-247, 259-260, 263, 270-287, 296-298. The Sloane Parties knew that Baldoni had not sexually assaulted Lively because Lively herself did not allege that Baldoni sexually assaulted her. Indeed, in her communications with the Daily Mail reporter in August 2024, Sloane affirmed, falsely in fact, that the issues on set had nothing to do with Lively. If Sloane believed that Baldoni had sexually assaulted Lively, that obviously would not be the case. The Wayfarer Parties allege that the Sloane Parties and their co-conspirators exaggerated benign interactions on set to concoct a false narrative that Lively had been sexually harassed. FAC 17. They did so, per the FAC, so that Lively could instill terror in the Wayfarer Parties and leverage it to accumulate power over the production. FAC 17 175-178. See Biro v. Condé Nast 963 F. Sup. 2D 255, 277, SNY 2013. Citing Kipper v. OIP Holdings Co. Inc. 12N.Y.3d. 348 355 N.4, 2009. Motive to defame plaintiff is probative of actual malice. This accumulation of power, akin to a hostile takeover, depended upon the ability to conjure ruinous allegations. FAC 296. They were never true, and the Sloane Parties knew full well they were never true. Fac opt. Shaptes prezice, 328. The depravity of their plan, which the FAC alleges they carried out, clearly constitutes actual malice. Moreover, the Sloane Parties admittedly had in their possession materials which prove the falsity of their assertions concerning a smear campaign. Fac 272-78, 283-87. Indeed, the day of Abel's termination, August 21, 2024, Sloane called Nathan and gloated that she had Nathan's communications with Abel. FAC 14-238. If that were so, Sloane would clearly have known that the narrative advanced by the Lively Parties and Sloane Parties was false. Specifically, the 33 Case 1:24 CV10049 OBL Document 121 Filed 030625 Page 45 of 55 Wayfarer Parties had not engaged in a smear campaign, or done any of the acts attributed to them by the Sloane Parties. FAC 274-78. By way of example, while the Sloane Parties provided the New York Times with text messages concerning purported allegations of sexual misconduct, she and her co-conspirators apparently omitted the subsequent message that the allegations were not true. FAC 162. And as for the untraceable smear campaign, it would have been clear to the Sloane Parties' public relations professionals that the cause of Lively's bad press was her decision to hawk liquor and hair care products while promoting a film about domestic violence. Fac 179-87, 279. The notion that the backlash was actually caused by an untraceable smear campaign is so inherently improbable that only a reckless person would have put the claim in circulation. Church of Scientology International, 238 F.3d at 174, citing St. Amant v. Thompson, 390 U.S. 727, 731, 1968. There were obvious reasons to doubt the veracity of these statements, which the Sloane Parties disregarded. ID taken as a whole, the FAC alleges sufficient facts to infer actual malice on the part of the Sloane Parties and the other defendants. Finally, while the FAC satisfies the Wayfarer Parties' pleading burden under an actual malice standard, it is important to note that 6 of the 7 Wayfarer Parties are almost certainly not public figures, i.e. Heath, Sarowitz, Abel, Nathan, IEWU and Wayfarer. Mere involvement of a person in a matter which the media deem to be of interest to the public does not, in and of itself, require that such a person become a public figure for the purpose of a subsequent libel action. Reader's Digest, 37 calories 3d at 254, citing Time, Inc. vs. Firestone, 424 U.S. 448, 453454, 1976. Lubers vs. Uncommon Productions, L.C., 663 F.3d6, 18-19, First Circle 2011. Defending oneself publicly does not forfeit status as private figure. Coleman vs. Grand 523 F. Sup. 3d 244, 255-57, Eden Y 2021. Same. In any event, because the FAC satisfies the much higher burden of pleading actual malice as to all of the Wayfarer Parties, it is unnecessary to separately analyze the lesser standards. 34 Case 1:24 CV10049 Eldrell Document 121 Filed 030625 page 46 of 55D. The Wayfarer Parties have adequately pleaded a claim for civil extortion as set forth above, supersection 4. B. The proper law to apply in this case generally is the law of California. Here the harm was particularly felt in the state of California, which is where nearly all of the Wayfarer Parties are domiciled and where the international film industry is focused. Under that law, the Wayfarer Parties have plainly stated a claim for civil extortion against the Sloane Parties. The Sloane Parties attempt to argue that the extortion claim is duplicative of the defamation claim because the threats by which the Wayfarer Parties were extorted involved spreading lies that the Wayfarer Parties engaged in sexual misconduct. This. Br. At 7-8, but the very criminal statute on which California's civil claim for extortion is based specifies that f-ear such as will constitute extortion may be induced by a threat of any of the following. 2. To accuse the individual threatened or a relative of his or her or a member of his or her family of a crime. 3. To expose or to impute to him, her or them a deformity, disgrace or crime. 4. To expose a secret affecting him, her or them. Calpen. Code 519. Notably, extortion lies whether these statements, which facially resemble the grounds for a defamation claim, are false or true. Flatley vs. Morrow. 39 calories. 4th 299 330 2006. Whether Flatley in fact committed any violations of these various laws, as threatened to be revealed by extorter, is irrelevant. Furthermore, a claim for extortion does not require that the threat actually be carried out but only that the threat be made. ID. In other words, the facts sufficient to state a claim for extortion, such as an unconsummated threat to accuse a person of wrongdoing, whether true or false, are in some ways the inverse of a claim for defamation, which requires the actual, not merely threatened, disclosure of factually false accusations. These diametrically opposed elements cannot logically give rise to duplicative claims. The Sloane Parties further claim that they cannot have engaged in extortion because they did not obtain property from the Wayfarer Parties by means of threats. This is false. California Law 35 Case 1:24 CV10049 Obel Document 121 Filed 030625 page 47 of 55, prescribes extortion notwithstanding that the defendant ultimately obtained no money or property by means of his extortionate threats. Monex Deposit Co. vs. Gilliam, 666 F. Sup. 2D 1135, 1137 CD Cal 2009. To the extent that the court determines that the Wayfarer Parties' factual allegations do not satisfy the Twombly-Iqbal pleading standard, the Wayfarer Parties are armed with additional facts that they will set forth should the court grant them leave to amend. As an example, the Wayfarer Parties are reliably informed and believe that the Sloane Parties deliberately carried out the very threats that Lively used to extort control of the film. Upon information and belief, the Sloane Parties widely disseminated false allegations that the Wayfarer Parties had engaged in or covered up sexual misconduct, just as Lively threatened she would do. Actually carrying out an extortionate threat does not eliminate liability for extortion. Flatley, 39 calories 4th at 331-32. People vs. Umana, 138 calories app. 4th 625, 640, 2006. Although Cal Penal Code Section 519 Subdivision 2 speaks in terms of accusing the extortion victim of a crime, there is no reasonable basis for drawing a distinction between the initial accusation of a crime and continued pursuit of a criminal charge. The Wayfarer Parties are reliably informed that these communications began well before the premiere of the film and the sudden downturn of Lively's public perception, and allege that the Sloane Parties did so in order to keep the Wayfarer Parties in line by instilling fear of Lively's threatened retribution. Under California law, a threat of harm by third parties constitutes extortion. People vs. Hopkins, 105 calories. App. 2D 708, 710, 1951. By playing the role of the heavy and carrying out Lively's extortionate threats, the Sloane Parties took an inexcusable part in Lively's scheme, and are therefore liable for civil extortion by conspiracy. The first amended complaint states a claim for civil extortion against the Sloane Parties, and the motion should be denied or at most granted with leave to amend. E. The Wayfarer Parties have adequately pleaded a claim for false light invasion of privacy 36 Case 1:24 CV10049 Algol Document 121 Filed 030625 page 48 of 55 for all the reasons set forth above, supersection 4. B. The law of California must apply to the Wayfarer Parties' claim for false light invasion of privacy. While the Sloane Parties argue that courts of this district have applied New York law to false light claims brought in New York, those cases are distinguishable. In De Julius v. Engel, the plaintiff freely chose New York as the forum, whereas here the Wayfarer Parties were made defendants in Lively's action before they filed their claims in the same court. De Julius 2021 WL 4443145 at 10. The plaintiff chose to sue in New York because of defendants' contacts with New York. Similarly in Barrick v. New World Network Intern, Ltd., No. 06CIV, 2641 JGK, 2007 WL 949767, SNY March 28, 2007. He plaintiff's relevant business dealings were in New York. Barrick 2007 WL 949767, at 7-8. Here, unlike in De Julius and Barrick, the only substantial tie to New York that is before the court is the fact that the Sloane Parties reside in New York. That is insufficient to overcome California's strong interest in this action, given that 6 of the 7 Wayfarer Parties reside in California, and the 7th is a resident of Illinois, not New York, who is linked to this action through his interest in Wayfarer. That the corporate entity plaintiffs are incorporated and or have their principal place of business in California, and that the Wayfarer Parties suffered the reputational harms and economic losses at issue primarily within the state of California. La Luna enters. Inc. 74F. Sup. 2D at 389. Under California law, the false light claim is not duplicative of the defamation claim. The cases that the Sloane Parties cite for this proposition are inapposite. First, Deaton v. Napoli, No. 17 CV 4592 R/B, 2019 WL 473672, at 9 Eden Y September 27, 2019, does not even mention false light claims, but instead addresses the overlap between tortious interference and defamation. Furthermore, Cord Assox, LCV, Protect 2003 DLC, Number 07CV5138 JFB-AKT, 2010 WL3780380 at 4 E. DNY September 21, 2010, does not address California's law on false light claims, but merely dismisses the claim as unavailable under New York law, adding in dicta that the same 37 case 1. 24 CV10049 Ulgul Document 121 Filed 030625 page 49 of 55 allegations underpin both the claims for false light and defamation asserted in that case. California law, by contrast, has long recognized that the torts of false light and defamation are distinct claims with related, but separate, elements. See e.g., Price v. Operating Engineers Local Union No. 3, 195 Calories App. 4th 962-970 2011. False light is a species of invasion of privacy, based on publicity that places a plaintiff before the public in a false light that would be highly offensive to a reasonable person, and where the defendant knew or acted in reckless disregard as to the falsity of the publicized matter and the false light in which the plaintiff would be placed. See also Fairfield v. American Photocopy etc. Co., 138 Calories App. 2D82, 86-87 1955. The right of privacy concerns one's own peace of mind, while the right of freedom from defamation concerns primarily one's reputation. Furthermore, California courts do not dismiss false light claims as duplicative of defamation claims, but determine whether a false light claim stands or falls, based on whether it meets the same requirements as the defamation cause of action. Eisenberg v. Alameda Newspapers, 74 Calories App. 4th 1359, 1385, 1999. See also Jones v. Dollar Tree Stores Inc. No. CV 21-7441 PA PVCX. 2021 WL6496822 at 5, CD Cal November 4, 2021. The court finds that plaintiff's false light claim survives the pleading stage because it is based on the same statements as the defamation claim, which claim is supported by sufficient factual allegations. Applying California law and citing Eisenberg 74 Calories App. 4th at 1385. Kevin Zhang Inc. v. Russia, No. 2:20 CV6247 SVW, 2021 WL1570837 at 6 N.4, CD Cal January 27, 2021. Same. Hogan v. Weymouth No. CV 19-2306 MWF AFMX. 2020 WL8028111 at 11 CD Cal November 13, 2020. Denying motion to dismiss false light claim based on same allegations as defamation claim and citing Mayweather, 10 Calories App. 5th at 1264. Any overlap in the allegations underlying the claims for false light and defamation is not, as the Sloane Parties urge, a reason to dismiss the false light claim as duplicative. Rather, it simply means that the two claims will likely rise or fall. 38 Case 1. 24 CV10049 Aljal Document 121 Filed 030625 page 50 of 55 together. See Eisenberg 74 Calories App. 4th at 1385. Jones 2021 WL6496822 at 5. Kevin Zhang Inc. 2021 WL1570837 at 6. Hogan 2020 WL8028111 at 11. As with the defamation claim, to the extent that there exist any defects in the Wayfarer Parties' allegations as to the nature of the statements made by the Sloane Parties to others, the defects can readily be cured by amendment. Courts applying California law readily grant leave to amend claims for false light. See e.g., Skidmore v. Regents of University of California, No. 20 CV06415 BLF, 2021 WL843195, at 2, ND Cal March 5, 2021. Granting leave to amend false light claim even in the face of California's stringent anti-SLAPP law. Hogan v. Weymouth No. CV 192306 Mufafmx, 2019 WL11055032, at 5, CD Cal August 19, 2019. Granting leave to amend false light claim. Brahmana v. Lembo No. C09-00106 ARM W. 2010 WL9652996. At 4, ND Cal March 17, 2010. Same. For example, the Wayfarer parties are reliably informed and believe, and based thereon can allege, that the Sloane parties engaged in a protracted campaign by which they contacted multiple reporters, including but not only at the New York Times, to spread highly offensive falsehoods and misleading information relating not just to Baldoni, but to each of the Wayfarer parties, and that they did so in conspiracy with each of the other defendants. Of course, because the Sloane parties' conspiracy was secretive and carefully concealed, the evidence must necessarily emerge through the discovery process, which the Wayfarer parties have already begun. In the meantime, and consistent with Rule 15a, extremely liberal standard for amendments, the court should grant leave to amend to the extent it is not inclined to deny the motion in its entirety. See Federal R. Civ. P15a, 2. The court should freely give leave to amend a pleading when justice so requires. In Re-Inves. Funding Corp. of New York Secretary Litig. 100 FRD at 65, describing Rule 15 as embracing an extremely liberal standard with respect to amendment. F. Even if the motion were granted without leave to amend, attorney's fees are not available to the Sloane parties under Second Circuit Law 39 Case 1:24 CV10049 Algol Document 121 Filed 030625 page 51 of 55 as set forth above. The court should deny the motion in its entirety, or, in the alternative, grant the Wayfarer parties leave to amend their complaint. But even in the extremely unlikely event that the court grants the motion its entirety without leave to amend, the Sloane parties still would not be entitled to any recovery of attorney's fees in connection with their motion, because the Second Circuit does not permit the application of state anti-SLAPP laws when they conflict with the federal rules of civil procedure. As an initial matter, the Second Circuit has squarely held that California's anti-SLAPP law is inapplicable in federal court because it conflicts with Rules 12 and 56 of the Federal Rules of Civil Procedure. La Liberté v. Reed, 966 F.3d 79, 87, 2d Sierra 2020. A state law conflicts with the federal rules of civil procedure when it answers the same question as one of the federal rules. ID quoting Abbas v. Foreign Policy GRP. LC 783 F.3d 1328 1333, DCCIR 2015. California's anti-SLAPP statute creates a special motion to strike that requires outright dismissal unless the plaintiff can establish a probability that he or she will prevail on the claim. Proc. Code 425.16b, 3. The statute, thus, establishes the circumstances under which a court must dismiss a plaintiff's claim before trial, a question that is already answered differently by Federal Rules 12 and 56. La Liberté, 966 F.3d at 87, quoting Abbas, 783 F.3d at 1333-34. The pleading burden under Rule 12b-6 is to allege enough facts to state a claim to relief that is plausible on its face. Bell Atlanta Corp. v. Twombly 550 U.S. 544 570 2007, and it does not impose a probability requirement at the pleading stage. ID at 556. California's anti-SLAPP statute, however, abrogates that entitlement by requiring the plaintiff to establish that success is not merely plausible but probable. La Liberté 966 F.3d at 87, quoting Carbone v. Cable News Network, Inc. 910 F.3d 1345, 1353, 11th Circle 2018. Similarly, Rule 56 of the Federal Rules of Civil Procedure permits summary judgment only if the movant shows that there is no genuine dispute as to any material fact and the movant is entitled to judgment as a matter of law. Vet. R. 40 Case 1:24 CV10049 Algol Document 121 Filed 030625 page 52 of 55 Civ. P. 56, A. Where Rule 56 allows a plaintiff to proceed to trial by identifying any genuine dispute of material fact, California's anti-SLAPP statute nullifies that entitlement by requiring the plaintiff to prove that it is likely and not merely possible that a reasonable jury would find in his favor. Liability 966 F.3d at 88, quoting Carbone, 910 F.3d at 1353. Accordingly, as the Second Circuit has expressly held, California's anti-SLAPP statute cannot apply in federal court. ID at 88. The Second Circuit has not yet directly addressed the question of whether New York's anti-SLAPP law applies in federal court. Still, federal district courts in the Second Circuit, including courts in this district, overwhelmingly agree that the holding of La Liberté similarly precludes the application in federal court of New York's anti-SLAPP law, which, like California's, creates a special procedure mechanism, N.Y. CPR 3211G. H. through which defendants can invoke the anti-SLAPP law in a motion to dismiss. CEG National Academic of Television Arts and Size, Inc. vs. Multimedia Sys. Design, Inc. 551 F. Sup. 3D 408 432, S. DNY 2021. New York's anti-SLAPP law imposes a different and higher burden on the plaintiff at the pleading stage than the federal rules of civil procedure. Carroll v. Trump 590 F. Sup. 3D 575, 583-85, S. DNY 2022. Marin v. Legal Aid Society 605 F. Sup. 3D 547, 567 N.11, SDY 2022. Prince v. Intercept, No. 21 CV10075, Lap. 2022 WL5243417 at 18, SNY October 6, 2022. Kessner v. Buell 590 F. Sup. 3D 680 702, S. DNY 2022. Aft sub nom. Kessner v. Dow Jones & Co. Inc., No. 22 to 875, 2023 WL4072929. 2D CIR June 20, 2023. Other courts, such as this Honorable Court, have analyzed the New York anti-SLAPP law's fee-shifting provision as a sanction that conflicts with Rule 11 of the Federal Rules of Civil Procedure. Brady v. NYP Holdings, Inc. No. 21 CV 3482, Algel. 2022 WL992631, SNY March 31, 2022. Lyman J. As noted in Brady, Rule 11 permits a court to impose sanctions only after the adverse party has been given notice and a reasonable opportunity to respond. New 41 Case 1:24 CV10049 OWL Document 121 Filed 030625 Page 53 of 55 Yorks. Anti-SLAPP provision has no such requirement. A party may seek sanctions without providing any advance notice to the adverse party. ID at 11. Furthermore, under Rule 11 sanctions are permissive, while, under the anti-SLAPP provision, sanctions are mandatory. ID. The sole federal decision on which the Sloane parties can rely in support of their argument for an award of attorney's fees in the event of dismissal without leave to amend is Bobulinski v. Tarlov, No. 24 CV 2349 JPO. 2024 WL4893277, at 11 to 14, SDNY November 26, 2024. In Bobulinski, Judge Oatkin found that the defendant's entitlement to an award of attorney's fees under New York's anti-SLAPP law is substantive and not procedural, and therefore held that applying the state law in federal court would in that respect be consistent with La Liberté. Importantly, however, Judge Oatkin's ruling acknowledges that his decision in Bobulinski conflicts with the decisions of other judges in the Southern District of New York that have found that the New York anti-SLAPP law's fee-shifting provision does not apply in federal court, including this court's holding in Brady. Bobulinski, 2024 WL 4893277, at 17 N.24. In short, it is settled law in the Second Circuit that California's anti-SLAPP statute is inapplicable in federal court. And while the Second Circuit has not yet expressly taken up the same question as to New York's anti-SLAPP law, Virtually all of the courts in the Southern District of New York that have done so have found that law liberté applies with equal force to bar the application of that law in federal court because it imposes a burden on plaintiffs that is inconsistent with the federal rules of civil procedure. G. The motion to strike should be denied or, at most, granted with leave to amend. The timeline contained in Exhibit A was attached to the first amended complaint in an effort to provide a complete and chronological account of the facts underpinning the Wayfarer Parties' claims and to incorporate as much evidence as was then known in support of those claims. 42 Case 1:24 CV10049 Algol Document 121 Filed 030625 Page 54 of 55. Nevertheless, the Wayfarer Parties acknowledge that the mountain of evidence in support of their claims must seem overwhelming to the Sloane Parties. Should the court grant the motion to strike with leave to amend, the Wayfarer Parties will undertake to judiciously incorporate the allegations and evidence from Exhibit A into the body of the complaint, in the hope that the Sloane Parties will then find it less burdensome to mount a defense to the Wayfarer Parties' allegations if they can. V. Conclusion. For all the reasons set forth herein and to be presented at oral argument should the court order it, the Wayfarer Parties respectfully urge that the court deny the motion in its entirety. In the alternative, should the court be inclined to grant the motion in whole or in part, the Wayfarer Parties respectfully request that they be granted leave to amend their complaint as stated herein. 9. Respectfully submitted, dated March 6, 2025. New York, Meister Selig and Fine plc by S. Mitchell Schuster Kevin Fritz 125 Park Avenue, 7th floor New York 10017. Telephone 21265535500. Email ms@mif-law.com. Coffetmsflaw. Com 9. Defendant. The New York Times has filed a simultaneously pending motion to dismiss, Diki number 105, and there remains a possibility that Lively and/or Reynolds may yet move to dismiss. Without conceding the merits of this motion or any other pending or potential motion to dismiss, the Wayfarer Parties propose that the court set a deadline for amending the complaint that falls after all pending or potential motions to dismiss are decided, to allow the Wayfarer Parties to correct any identified defects at once and to avoid burdening the court's docket with seriatim amendments. 43 Case 1:24 CV10049 Obel Document 121 Filed 030625 Page 55 of 55. Dated March 6, 2025. Los Angeles, California. Liner Friedman Tadelman plus Cooley by S. Brian Friedman Brian J. Friedman Miles M. Cooley Teresa M. Troop Son Summer Benson Jason Sunshine 1801 Century Park West, 5th floor Los Angeles, California 90067. Telephone 31020100005. Email friedman@lfdulp.com. Cooley@lfdulp.com. Tripson@lfdulp.com. Spenson@lfdulp.com. Junshine@lfdulp.com. Admitted project.